is there a reason to allocate this risk of a sudden import ban in Iran to one of the two parties? So if the contract is avoided, then we have shifted the risk to back, right, to the beer producer. If the contract is not avoided, we have shifted the risk to the export firm. You could again ask what the parties themselves would have agreed to in a fully specified contract if they had thought about this ex ante. Who was?
Taking in the product, buying the product, which is the importer of the business, the domestic seller of the factory.
Yeah, but there is the domestic seller, you know, he's out of the game altogether. He is sitting in Iran. That, yeah, you are right, but that was not no possibility. There was a revolution in Iran, and the only way of shifting the risk was not to this guy who is in Iran, but only between the German exporter and the producer of beer. Because that would be simply a waste of money. Now assume that that you sue the Iranian importer. Where do you sue him? At which court? He's sitting in Iran. And if you sue him in Iran, with the mullah court or whatever, I don't know, you know. You can better save that money. And if you sue him in Germany, yeah, he will not, nobody will show up and so on. And then you get, of course, a court order. But you have to send the court order to Iran. And then again, you have to wait that it is enforced. So forget about this. So you see, is that convincing? So that you leave out. Okay. Yeah.
If the beer exporter has an alternative market,
Yeah.
which is larger than the producer,
Yes.
then maybe the exporter can retain that entire substance and sell it to other places. But if the producer also has an equally big or a larger market, then the producer should ideally perform the contract, take all the substances, and sell it to other places.
Yeah, well, so your solution would be that the producer should take the risk.
If they have a larger market and that risk can be absorbed by that alternate market.
Yes, I think that is, I agree insofar as that will probably happen. They can sell that to somebody else, right? So I don't think that for this reason, for just the reason which you mentioned, the Beck's company would insist on specific performance and would you insist you must take our beer and then what you make with it, you know, it's your thing. That probably they will not do it. I don't know the details so much of the case, but I think that what was at stake was not that the beer was physically sent to the exporter, but that they keep the beer, sell it somewhere else, but they want the profit. So they have produced the beer, let's say, at a cost of 100 and have sold it for 120, and they want these 20. And then they can, but for that they need a court order which say this contract is still valid. And then, of course, it is peanuts to negotiate that you pay only the difference between the cost and the price. See what I mean?
I think the producer will be entitled to opportunity cost in this case, because my sense is that the trader is engaged in, the trader does not inherently create any value. He matches buyers to price sheet, and therefore if you eliminate risk entirely from a trader, he's entitled to all the profits when the contract goes well.
Yes, yes, I agree. Yeah, yeah. Yes, you see, we have here a similar problem, economically speaking, even though doctrinal, the two cases are very different doctrinally, but economically they are very similar. This case is similar with the aviation case, with the pet food, because Beck's company, they are producing beer. That is their business. So they concentrate on making good beer, right? It is not their business to find out whether there is a revolution in Iran or what the consequence of that is. But then you have this specialized export firm which specializes in these markets. And, you know, this is nothing special. In the Muslim countries or Arab countries, and even in some Indian states, you have all the time. Sometimes you have an import ban, then you have prohibition, then you have no prohibition. Then it changes all the time, you know. And if somebody knows this, then it is not Beck's, but this special exporter who makes a business just of it, knowing these things, and he is therefore the cheapest risk taker, and he should take the risk. See what I mean? And therefore, and again, well, you could argue that in a fully specified contract, this risk both parties would have shifted not to Beck's, which would then have said, well, if I should take this risk, I'm not an expert, then I want a high markup on my price. And then the exporter would have said, no, I don't pay you that high markup, then I better take the risk myself. You see, that is always the way we think about it when we allocate the risk, also when we construct legal rules, and also in the courtroom. Now comes a funny case which everybody who learns contract law in Britain has to learn, and I want to have your view on it. That is a real case, even though not a very important one. The King Edward case. King Edward became King of England I think in the year 1908, if I'm right. And then this was celebrated with a big procession, with all the pomp and circumstances of the British Empire in London. Now, for this procession, many people wanted to see it, and therefore, at the road where the procession went through, the owners of houses, they rented out their balcony, so you could rent a balcony and go then there with your family and see how the king and all these queens and whatever, how this procession was. And now somebody hired such a balcony, but then for some reasons the route of this procession was changed. So there was no balcony. And now the point was here then that the person, the tenant who had rented the balcony, he said, well, that makes no sense. You know, the contract must be avoided. I have only booked this for this particular purpose, and the other side knew it, and therefore I would have, I don't pay. And the landlord, however, had argued that of course you must pay. You know, the reason why you rented it, that is not my business. You rented my balcony for 1 day, and I gave it, or I offered it to you, so you can have it for 1 day. So, and yeah, the British have a certain sense of curiosity, because that case, even though it was a small price, went up to the House of Lords and then made it into the textbooks of contract law and so on, you know. Pardon?
This case was taught to us also as part of the contract.
Yeah? Okay, good. Typical English case. Yeah, what would you say? Pardon? Why?
Because according to the terms, they said that they wanted to lease out the balcony for just a day. Now it's their duty, the one who has hired.
Why?
The one who has taken the balcony to check out what will they make out of that balcony for a day. It's not the duty of the homeowner.
Well, assume that these two parties would have sit down before and written a fully specified contract. Okay, fully specified contract. And also assume that they would have taken this risk into account. What would they have written down in the contract? Is there a cheapest cost avoider? The landlord? Why?
The landlord is the one who can make alternative arrangements, alternative commercial arrangements regarding his balcony.
No, he cannot. Because, you know, this was a private house, and where usually the balcony is never lent out. So it was lent out only for one particular occasion, once in 100 years, during the crowning procession. Does the landlord have any more better information about where the procession will go? No. They are totally equal.
If we compare these two situations, then there was no procession. For example, it was supposed to be at 5 o'clock.
Yeah.
And nobody turned up. Then the final liability would have rested with the tenant, because by that time tickets would have been sold, everything would have happened. And the tenant can do nothing about it. So he would have had to return the money and pay the rent to the landlord. So I think this can be compared to a similar situation. Even if money of the tenant is lost, then it is lost. And I mean, using pure common sense, in the second situation, where there was no possession, the tenant would have incurred a loss. So I think the cheapest cost avoider in this case would be the tenant. Actually, not a cost avoider, but the liability would rest with the tenant.
Well, you know, I think that in a fully specified contract, nobody has better information than the other. In the other case, compared to the other cases, nobody has better information than the other party. But if they would have thought of this risk, then the outcome would have been the following. They would have said, well, either if for whatever reason the possession is not at the balcony, then the tenant has the right to withdraw from the contract, right? That would be one possibility. The other possibility would have been that they said, well, we don't know, but it is possible. Therefore, if the possession is not taking place, that then the contract is still valid and we must pay the full price, but the price will be much lower. These are the two possibilities in a fully specified contract. You agree? Now, what makes this case so tricky for the court is that assume they had agreed that in a fully specified contract that the contract is valid, but the price is low. You have such cases often, but then you can compare this low price with market prices, you know, and then you can say, well, you know, this is a contract, but it is a valid contract because that is reflected. The risk is reflected in the market price. The risk has been shifted to the other side who gets a bargain price. You see? So if you have such a situation and you can see that implicitly the risk was shifted because the price is so low, then you can as a court say, well, this is a valid contract because I can see from the low price that this risk was shifted to the buyer, right? But here, that is the odd thing about this case, you don't have a comparative price. This market does not exist. So you cannot see, you know, whether that has already been implicitly shifted to the side. So this is a case in which I would say it is, you really cannot say what the economic right solution is here. You can simply throw a dice here or make it a 50-50 or whatever. But you see, these four cases, these were just cases to illustrate how the idea of a cheapest cost avoider somehow influences also court decisions. And I give you the last case from this, I give you one in which not only we have the problem of a cheapest cost avoider, but also of a cheapest insurer. There was a following case also in Germany. Somebody wanted to buy a new car. So he went into the car to the companies, the car seller company, and they had a car, they had their cars, and they had a huge campus there at their premises. And then the salesperson said, well, you can drive with this car, but the car was not, you know, it had no plate. So you could not drive on the roads, on the public road. You could only drive on this private place of the car seller. So, and the car was not insured and nothing. So the would-be car buyer drove with the car and caused an accident. You know, he just drove and hit another car, so 2 cars were demolished. And now the car dealer wanted damage compensation because it was not debated that the would-be buyer was negligent. He had negligently caused this accident. But he argued, he said, well, you know, if you had, if this car had been registered, it would also have been insured, right? And then if I had caused an accident on the road, then the car would have been insured and there would be for you no damage. The insurance company would pay it. Now you exposed me to a very high risk here, but you could have insured. I cannot insure, but you could have insured the car. And then the court actually said, yes, even though he negligently caused an accident, he's not liable for that, because usually under normal circumstances, this would not have led to his liability because we have forced insurance and the car manufacturer could have done this. And because he was the cheapest insurer, that an economist would say, the lawyers would say, use a different language, he is not liable. You see? Now, we come to the next big topic, breach of contract and related questions. Now, when we talk for breach of contract, this means that we have a contract, but one party, usually that is the party who owes the specific performance, does not perform the specific performance. Do you know what, can one of the lawyers briefly explain what specific performance is? Yes? Fulfilling the legal obligations, but what that is the performance of the contract, to perform the contract. But what do we mean when we talk of specific performance? Yeah. Yes. Well, you see, specific performance, usually a contract is somebody agrees to do something and the other agrees to pay the price for it. And both are performances, but to pay money is not very specific, you know. But to perform the contract, to produce a particular good, or to sell a particular good, or to provide a particular service, and so on, that is the specificity. So that is the specific performance, right? So we now deal with these problems. What should happen if there is a breach of contract in the sense that one party does not deliver the specific performance, right? Now, before coming to this, I have to point to a fundamental philosophical difference in the view what a contract is between in different legal orders. And we have here two views about what a contract is. A heavy view and a, let's say, light view of a contract. The heavy view is that a contract, under the heavy view of contract, that means this idea that a contract, if you perform a contract, if you conclude a contract, performance is mandatory. You have to stick to your promise. This view is very widespread on the European continent, also in Germany. And the legal consequence of that is that in principle, on the European continent and in Germany, the partner, there is a right to specific performance. So if the party which owes the specific performance does not deliver, then you can force the party to deliver. So there is, with the contract comes the entitlement to specific performance. There are, of course, exceptions from that, but that is the general rule. And in the Anglo-Saxon world, and I believe that as you have the common law system in India, it might be similar in India, there is a more light version of the contract. That is the contract. If you conclude a contract, it does not mean that you have a right to specific performance. So the judge, the famous judge Cardozo, an American judge, has once put it like this. He said, what is a contract? What is the promise in a contract? When I conclude a contract, let's say I have a contract with you to deliver a particular good, then what I promise is this. I promise to deliver you this good or not to deliver you this good, and if I don't deliver it, I pay you the damages. So the Anglo-Saxon law does not understand a contract in the sense that you promise something to the other side which you have to keep, but you can always step out of that and pay damage compensation. So, therefore, of course there are also exceptions in the Anglo-Saxon world. For instance, if you buy land, then the buyer has the claim to specific performance. Or if you buy a particular non-replaceable good, for instance, a painting, let's say if you buy particular Picasso or something like that, then you have a claim to specific performance. But that is not the general picture. The general picture is always that the seller or the person who owes the specific performance, he can say, okay, I told you that I have this obligation, but now I changed my mind, I pay damages. That is more the Anglo-Saxon way of looking at contracts. Now, we have to think about the question, when should a contract be terminated? When is it economically advisable to terminate a contract before the specific performance? And for that we go back to our, here you see we have here this graph with the total surplus of the contract, right? The total surplus. Now, assume that we have here the cost, we have the price, we have the willingness to pay, the total, this is the total surplus. But now, assume that that we have a contract at a particular date, and then time goes by, and it takes some time, you know, to prepare the specific performance. And all of a sudden, the costs to perform increase dramatically. Should then the contract be ended? What is the economic answer to that? Now, what would you say? This is the price. This is the cost here. The total surplus is this. Now, my question for you is: assume that these costs here are between the contract and the delivery increase. Is there a cost increase where you would say, from an economic perspective, it is so high that the contract makes no sense anymore and should be terminated?
The cost exceeds the willingness to pay.
If the cost exceeds the willingness to pay, yes. Now, assume that the cost would increase from here, let's say, to here. Then nothing changes, because still there is a producer surplus and the producer would still deliver. But if the cost would increase from here to here without any sanctions, now the producer would not deliver anymore, right? Because he makes not a gain. But there is still a surplus. But if the cost would increase, let's say, to this point here, then the total surplus from the contract would be negative. The sum total of consumer and producer surplus. So if therefore circumstances happen which destroy the rationale of the contract, which is to produce a Pareto, to produce some surplus, then it makes no sense. And then we must ask whether the rules of contract law give the parties an incentive to perform the contract, if that is still economically efficient, and to end the contract if this is economically not efficient. And the answer to that we will now analyze. I give you an example here. Assume there is an oil machine, an oil company, and the oil company buys drilling machines. And the oil company has ordered a drilling machine from a machine producing company, orders a drilling machine for the price of 100, and the costs are 80, and the value of the drilling machine for the oil company, because it makes profit, is 150. So we have a producer surplus of 20 and a buyer surplus of 50. And also the buyer has to fix a solid cement construction on the ground on which the drilling machine is placed, right? And that costs 10, right? So then the costs are 80, 100 is the price, the cost for the solid cement construction is 10, and the the value of the machine for the company is 150. Okay. Now this happens. There is another oil company, and from Brazil, let's say, and this oil company from Brazil, they have just found huge reservoirs of oil there, which they urgently want to produce. And for them, the machine is much more valuable. So they do not value it at 150. They value it at 200, right? And they need it much more urgent. So what would you say from an economic perspective? Where should this oil machine go? Should it go to the first buyer or to the second person, who is this Brazilian company, which is also interested? Let's call it the second buyer. Pardon?
To the second buyer.
To the second buyer. Okay. Why?
That will increase the total surplus.
That will increase the total surplus. So if here, the economically efficient solution of this problem is that somehow the first contract is avoided and the second contract becomes effective and the machine is going to the second buyer. Right. Now, assume that there's a third buyer who values the machine only at 130, right? Then it is obvious that the third buyer should not get the machine, because that would reduce the total surplus from the contract, right? But now assume that this third buyer offers the company, because he values it at 130, he offers the company, the seller, 110. Would the company then sell it to the third buyer? That would be economically inefficient, right? The first would be economically efficient. Now, we have now to ask what are the remedies of contract law? What are the actual remedies which we find in contract law? And are these remedies give their incentives to breach the contract, to end the contract when it is efficient, but not to end the original contract when it is not efficient? That is our question now. And now we can discuss several, or let's say three. There exist basically three norms. The one norm would be that the producer, if he breaches, he must pay the full damages. That is the full which includes the profits of the first buyer. We call this the expectation damages, right? Expectation damages. The expectation damage includes the full profit. The second rule would be the reliance damages. The reliance damages are those damages which cover the investment which somebody has made by trusting on a contract. That would only be the solid cement construction, right? How much would would in this case the expectation damage be? 50. He would have to pay 50 for the plus the Reliance investment. So, yeah. So his cost would then be 60, right? Okay. Now, first of all, we assume that we have a situation where there is no rule of law at all, you know, which you often have with, let's say, with countries which have a weak legal system. You simply cannot go to court. So the question is here, you know, when we go back to our original, now assume there were no legal system at all. What would have to happen? How high must the price be of the second buyer to induce the producer to breach the contract? Yes, if anyone offers a price which is higher than the previous price, then he will breach, right? Does that happen? It happens all the time. Now, you know, I give you an example of German importers of silk from China. When China started, you know, with its market economy, then there are German manufacturers which use silk. So they bought the silk in China after they opened up the market. Before in China they had a monopoly, an export monopoly, and all the negotiations had to be made with the export monopoly. And they could be somehow trusted because now it was all decentralized, and they made the contracts with the companies. And then they bought large amounts of silk for every month, and then the silk price went up, and then the Chinese companies did not deliver. They sold it somewhere else because the world market price for silk had gone up. And then they sent their lawyers there, and they said, what do you really think, that we deliver you the silk only because you have a contract? Yeah, that was, I mean, in the meantime, that doesn't happen anymore. But it is not that you can rely on a contract. If you don't have sanctions, then this happens all the time, you know. And therefore, if you don't have sanctions, if you don't have these legal sanctions, then you can rely on a contract only by social sanctions. But if social sanctions are also not possible or not at hand, then the contract is just like Russian roulette. You know, you can either, you can be lucky, you can like a lucky number if you draw a lucky number, you know. So that is the situation when you have no law. Then when anybody comes and offers a higher price, then he will breach. And that happens all the time. Not only in China, also in Germany, you know, that happens all the time. Now assume that the legal remedy for breach of contract is damage compensation, and it is reliance damages. That is, the damage compensation covers only those damages which the other party incurred by trusting on the contract. That is, it does not include the profit, the expected profit. In this case here, it would be the cost of the cement construction, right? That is 10. Now, assume we would have this rule. When is now, how much must now the second buyer offer that the seller breaches the contract and sells him the thing?
The difference between the new and the old price should be more than the Reliance investment.
Exactly. So if this is the old price, then if a new seller comes, then he must at least, so now assume that this is the Reliance investment here, then the price must at least be the old price plus the Reliance investment, because that money goes to the first buyer. And now comes the question, would this rule guarantee that a contract is breached if and only if this is economically efficient? That is, if the total surplus is gone. Why not?
You have to compensate the seller for losing just the Reliance investment, because his net earnings from this would not change.
Yeah, well, we had here a seller, we had here a buyer who values the machine at 150 and he paid 100, right? And his valuation was 150 and the total surplus from the contract was 70, right? That was our assumption. Now, assume that a second buyer comes who values the machine at 140, right? And however, he offers a price of 120, then it is profitable for the producer to sell the machine to the second buyer, even though the second buyer values it less than the first buyer. That is, the machine, by this breach of contract, goes not to the highest valued user, but to a lower valued user. You see? And this is a race to inefficiency. Pardon? Exactly. Therefore, we can say that in contract law, a rule which punishes breach of contract with Reliance investment does not lead to an efficient use of resources, right? Now we have to ask for the third rule, namely expectation damages. Expectation damages is the rule which is generally used also in my country, in your country, in France, everywhere. Only in the 19th century, I think some states in the United States where contract law is state law, not federal law, some states have used Reliance investment. They had a long discussion, and therefore you find this in the American literature, but it is not really relevant for us, for you or for Europeans. Now we ask whether expectation damages would guarantee that a breach is always an efficient breach, in the sense that the second contract would lead to a movement of the resource to the highest valued user. Now, my question is now, how much must a second buyer offer? Which price must he offer to the seller to induce the seller to breach the contract under the expectation damage rule? Yes?
More than the willingness to pay of the person.
Yes, exactly. So he must pay more than 150, but this is not a problem for this second buyer, which I mentioned from Brazil, you know, who values it at 220, and he said, look, I pay you a price of 170 so that you can cover the full damage compensation cost to the first, but the resource is now moving to the highest valued user. You see, and therefore one can argue, it is much still debated, and I come to that, but one can argue that the compensation of the expectation damages, which include all losses, including the lost profit of the first buyer, that this guarantees that if a breach occurs, then it is economically efficient. And therefore we talk about efficient breach of contract. That is something what some lawyers had difficulties to understand. But what is meant is that if we have the overarching view that resources should flow to the highest valued user, then there is something like an efficient breach. Okay, now, however, this has been criticized. So there was a fundamental critique of this, because there are those, and law and economic scholars are split on this point. They do not agree on this point, and there has been a series of very polemic articles on this, namely the following. The expectation damages, they, as we have seen, allegedly guarantee that the contract is only breached in case of if there is a higher valued user, and that is economically fine. But that has been contested by, or questioned by many people, including, for instance, Thomas Uhlen, with whom I once discussed this. He has written a very critical article. Thomas Uhlen is one of the authors of this textbook, Kuta and Uhlen, and he's a good friend of mine. And we discussed this case, Jacob versus Young, for, I think, for 2 hours or so. What the critics of this rule, what they say is the following. They say, well, damage compensation is economically must be the difference between the price and the willingness to pay, right? So that includes many items or many aspects which the law does not value or does not compensate. So, for instance, if sentimental value is destroyed, that is usually not compensated. Or some damages, they might be in principle be compensatable, but it is very, very difficult to prove the damage. Now, for instance, it could be that the first buyer, that he says, well, you know, of course, that was my profit, 50, but my losses are much higher because I lose also reputation for being a reliable merchant, right? But he cannot substantiate it. He cannot say how much it is, you know, and then he gets nothing for it. So these people, these critiques says that compensation of expectation damages leads systematically to undercompensation, just as compensation for takings. You know, if people lose their land, for instance, then they are not compensated for losing their homes. You know, this sentimental value is not compensated. It is also here not compensated. And many things are not compensated, though that leads to undercompensation, and the undercompensation again lead to a breakdown of the proposition that the compensation for expectation damages lead to an efficient breach. It might lead to an inefficient breach. So that is the critique. And these critiques, they say that the only legal norm which really guarantees that the contract is only ended if it is efficient is specific performance. The right to perform. Now, what does that mean? Under specific performance, the rule would be this. Under specific performance, now assume that under specific performance, the second buyer would come and offer 180 to the producer. And if then the first buyer gets notice of this, then he can, by a preliminary injunction, stop this, you know, and avoid that second contract and force the seller to deliver it to him. Or if he does not get notice, and you know the seller sells it and it goes off to Brazil, then the claim of the first buyer is not his damage, his expectation damages, but the disgorgement of profit. Then the seller would have to disgorge him not the 80 profits which he made from the breach. So no, he must give him the profits from the breach. Now, how much is the profits from the breach here? Huh? No, you know the cost was 80. The price was 100. The original price for the first buyer. His profits were 50. The first buyer, the price was 100. The 50 was his profit, and the price for the second buyer was 180. Now, how much profit did the breacher? How much did the seller profit from the breach? No, from the breach. Bitte?
Because 20 already was getting him first one. If you breach it, the extra which he gets is 100 minus, means 180 minus 100, which is 80.
Yeah, you know, if he had not breached, he had made a profit of 20, right? So the profits from the breach are 80, but from that you have to deduct the compensation of 50, because that he would have to pay in any damages. So the profit from breach are actually 30. So therefore, the first buyer would in this situation get 50, that is his compensation, plus the disgorgement of these 30. See what I mean? Now, what would happen if that is the rule? Assume that this is the rule. What would the consequence then be? There would be no breach. There would be no breach. And now you can say, or some economists say, if there would be no breach, because there is no incentive, you can never make a profit from a breach of contract, because you must all give all your profits to the other side. If there is no breach, then there is also no efficient breach.
The two buyers will now bargain.
Now what happens here is the following. Now we have this situation, we have the first buyer who pays a price of 100 and makes a profit of 50, and we have the second buyer who makes, who values it 200 and pays 180. And the first buyer, however, can prevent this breach. So in this case, the producer will go to the first buyer and say, look, here we have this situation. There is somebody who badly needs the machine very urgently, and he values it much higher than you. He offers me, the producer, a price of 180. Therefore, what I suggest is we make a deal, we make a contract to end our contract. And for that, I pay you your profits, you get 50 from me, plus half of the profits which I make. So I give you 65. Then I still make a profit, an additional profit of 15. And that is a win-win constellation. So they would agree to terminate the contract, and the contract is terminated, and the resource will go to the highest valued user, also with specific performance, right?
So, but why should first buyer agree to it? And if that contract is not ended, and buyer one buys it from the seller, and then he enters into the contract with the second buyer, and he gets to retain the entire contract.
Yeah, because the first buyer would, he is better off than if the contract had been met, right? What is your argument? You mean that you could also say the first buyer?
I'm saying that the producer is offering him half the profit that he's making.
Yes, yes.
I'm saying that if the buyer continues with the contract, and then he makes another contract with the new buyer, the second buyer,
I
then
see.
he retains the entire profit.
Yes, but you know, if that is the case, you know, then the producer has no incentive at all to reveal this to the first buyer. He simply delivers it, and you know, because he cannot gain anything from that. You see? So that would also make the situation problematic, because if the producer cannot gain anything from it, then he will not disclose his knowledge. Then he will simply deliver, and that's it.
But if it is like a one-shot game, once he's revealed, now
No, I mean the first buyer would never know that there is a second buyer. You know, the first
but
buyer.
if the seller goes with the hope that he will agree, the buyer will agree, to distribute the share.
Yeah.
Not 50-50, but whatever proportion.
Yeah,
The
now,
buyer has got the information and now he deviates.
yes, that's right. That's a good point. You can say, okay, he must say, I have a very important information for you, which is worth 15 million rupees, let's say. And if you agree, then I tell you what it is, you know. He cannot disclose it. So then